Thank you, Mr. Speaker. I want to first begin by just referring to the contribution that was made by the Māori Party on this, who were essentially seeking assurances from the government that some of the issues that we have raised will be addressed. And I'd just like to say to the Māori Party, who at this stage are supporting this bill, we have raised these issues in Select Committee. We've raised them directly with the Attorney-General and to date have reached no satisfactory conclusion. So it is therefore, that is the reason why the Labour Party will not be supporting this bill, and I would urge the Māori Party to reconsider, given I'm very sceptical that they will receive the assurances that they're seeking. Obviously, speakers have already traversed the background to this bill, the fact that essentially when it was first presented to this House, it focused on this notion of courts making better use of new and advanced technology, basically the use of audio-visual links in criminal and civil proceedings. And the criteria, the government's criteria that was put before us, the reason why they argued so strongly in favour of the use of AVL was for three substantive reasons. One was the cost, the savings that could be made, the efficiency, and then finally the issue around safety of other participants in proceedings. And for certain areas of criminal matters, we agreed with that, and we highlighted that in the first reading, that for simply procedural matters, remand, etc., we had no objection to AVL technology being used in that regard. But where we do object, and where we continue to object strongly, is the proposal that for substantive criminal matters, AVL technology could be used, thereby removing the ability of an accused to be present at their trial. And why is that? Well, because we weren't simply using a set of criteria that sat around cost, efficiency and safety. We had in mind another set of criteria which is enshrined in our law and going well beyond even the history of this Parliament. And that is the criteria that we would all know well, that when it comes to criminal matters, there should always be a presumption of innocence, the right to face your accuser, and the right to be judged by your peers. And elements of this bill fundamentally remove those rights. And that was the set of criteria that we judged this bill on, and it has failed. I do want to reflect briefly on the part of the bill which has become the most contentious, for those who may be interested, and that is Section 9, which states, AVL must not be used in any criminal substantive matter for the appearance of a participant unless a judicial officer determines to allow its use for the appearance of that participant in the proceeding, in accordance with the criteria set out in Section 5 and 6, and I will go over that criteria because I think it proves a useful point, and taking into account whether the parties to the proceeding consent to its use. Now, Chester Borrows, who is the chair of the Select Committee which considered this bill and is an excellent chair, did raise what he considers to be the high bar that is set out in this part. But I think in doing so still demonstrated our point. There is a bar, but of course any bar can be jumped over. And in fact, there is still the ability to have an accused fundamental right removed via this clause. The judicial officer has complete discretion. They're able to take into account the views of other parties, but there is no compulsion for them to take into account, for instance, the accused's position against AVL technology being used for their substantive trial. And I guess really if we were to simplify this argument down, I would ask members of this House, if tomorrow any of us were in a situation where we were going to face a trial on a substantive criminal matter and we were giving the option of using AVL technology to appear or to observe that criminal, our own criminal trial, would we opt to use it? And I would assume, because I know certainly in my case I would not, I assume the position of many in this House would be to say no. And why? Well, I think it's quite obvious, and in fact the criteria demonstrates this point, because it forms a detachment between the accused and the proceedings which are so vital to the trial that they face. And actually, if we go through the criteria that a judicial officer is required to consider in determining whether or not AVL technology will be used, this is what it sets out. That a judicial officer in Part 6 must take into account the ability of the defendant to comprehend the proceedings and to participate effectively in the conduct of his or her defence, to consult and instruct counsel privately, to access relevant evidence, and to examine the witnesses for the prosecution, and the level of contact the defendant has with other participants, and any adverse impression that may arise through the defendant or any other participant appearing by means of AVL, and whether that adverse impression may be mitigated. Now, what I find interesting there is that actually that criteria sets out all of the detrimental impacts that the use of AVL may have in a substantive criminal proceeding. It sets out all of the reasons why it could limit an accused access to justice in their own substantive trial. And I think it shows and demonstrates the fundamental difference between appearing before the court and observing it from behind a screen. And if we were to relate it to something that we all know well, I've heard Select Committee has already been raised as a very good example where we as Select Committee members have experienced the wall that is generated by communicating with an individual via a video link. But in the same way that anyone who watches the proceedings of Parliament via their television will not feel a part of the proceedings in this place, versus someone who is sitting here amongst us as a participant in what goes on here. And I think that that is the best way that we can describe the distance between an accused who appears via AVL and accused who is able to be present there for their own trial. Not to mention the access that person has to their lawyer, who of course will need to be present for the substantive trial and will not be able to communicate with them via a video link as the proceedings occur. I think that sets out very clearly all of the reasons why we should exercise caution with this clause, and that has not occurred in the way it's set out currently. I want to very briefly raise a quick point that I find it contradictory that the government is willing to hand over, when it comes to the fundamental civil liberties of an individual, hand over discretion over that to the judiciary, and yet when it comes to 3 strikes, they've removed all discretion from the judiciary, because in that case they might somehow hand down a penalty which might not be the maximum, which is obviously what the government strives for here in every case. So the discretion of the judiciary, that's obviously something that the government will give and take at will. We've had other members already talk about the fact that the Attorney-General came forward and said that he didn't feel that there'd been any breach of Section 7. When the Attorney-General came before the Select Committee and appeared on another matter, we raised this issue. We asked him to clarify that this was his intention when he first reviewed this legislation, that for substantive trials an accused could be refused the right to appear. We have not yet had that advice back, and I really would urge the Attorney-General to proceed quickly with that advice for the benefit of the whole House. And I want to highlight again that the New Zealand Law Society submitted that AVL should not be used for substantive criminal matters, and as did the Human Rights Commission, and that has been discussed at length. Mr. Speaker, I want to highlight finally that in this case I would have expected the Minister of Justice to be seeking an absolute majority on this significant issue, but instead he has chosen to exercise power rather than wisdom.
I call Kanwaljit Bakshi.